Good evening, everyone, and welcome to MSU FCU's Financial Education Seminar Series. We appreciate you all joining us and are excited to be here with you virtually this evening. These presentations were created with you in mind, with the intention to give financial education on a number of relatable topics to help expand your knowledge of finances. Each event will be hosted by a member of our financial education department or by one of our partners, connecting you with resources in our community. We have a number of diverse presentations planned for you this year, and you can explore and register for them by visiting us at msufcu.org/events. Tonight's event is being recorded. To rewatch or share the presentation, you can go to youtube.com/msufcu and then select the seminar series play from the playlist options. Recordings are usually available in about 3 weeks. You may send your inquiries at any time during the event, which will then be answered in the order they were received. We'll also provide additional information and resources in the chat, but please reserve the Q&A panel for your questions. I'm Therese Bacon, and I'll be your facilitator this evening. If you have any concerns or technology issues, I invite you to reach out to me in the chat. Again, questions for our presenters should be submitted through the Q&A. Tonight, we have a very knowledgeable guest joining us to present on trust creation and administration. Allow me to introduce our host, Michelle Lane, who is an attorney with Chalgian Tripp Law Offices. Welcome, Michelle, and thank you so much for joining us. I'll pass it over to you to tell our audience a little about your position with Chalgian Tripp, and then we can lead right into your presentation this evening.
Thank you, Therese. So I am not new to these seminars that MSU FCU hosts, and in previous years and months, I have done seminars on estate planning, focusing on taking care of aging parents. This seminar is more like what I've done is a bird's eye view in the past of estate planning. This seminar is more focused, and we're zeroing in on trust creation and administration. As Therese said, I'm a lawyer with Chalgian Tripp Law Offices, and we have offices throughout the state of Michigan. I happen to work out of the East Lansing office, and but we have, as I said, other attorneys around the state. Our primary practice areas are estate planning, estate and trust administration. We do a fair amount of litigation with regard to estates. Special needs planning, government benefits in terms of long-term care, and protecting vulnerable adults. So we have a widespread area, but what we don't do is family law or bankruptcy or personal injury. So we are pretty focused on a specific area. So tonight, I am just bringing you some slides and presentations based on questions that I hear from my own clients, and hope you'll enjoy the seminar. There is a lot of information, so I will try not to go too quickly. But as Therese said, there is an opportunity for question and answer. So you can select that option and ask questions, and then we'll be able to address them. All right. So trust creation and administration, what you should know about trust. I'm going to start, like any good lawyer, I'm going to start with a disclaimer because this is a seminar to introduce you to the discussion of trust, but this is not meant to be legal advice. Obviously, there are a number of you out there with various issues, concerns you might have. This presentation is not it was not done with the idea of answering those specific issues. Also, what you need to know is that the world of trust is huge. What we're talking about tonight are your really common everyday trusts that would apply to most people. But realize that there are a variety of trusts available and out there, ranging from what we call irrevocable trusts, special needs trusts or government related trusts. There are charitable trusts, which are specifically trusts that name charities as beneficiaries. There are pet trusts. I have clients who value their pets and want to make sure their pets are provided for when they die. So we have pet trusts for those clients. There are gun trusts. We are in Michigan. Michigan is a gun-carrying state, and we have lots of people who have gun collections, hunting rifles, etc. So we have gun trusts. There are cottage trusts. Again, Michigan is a pretty good large cottage state in terms of having properties, cabins and cottages up north that have been in families for a number of generations. So there's sometimes a need for special types of trust, cottage trust. All that to say, there's a lot of trusts, and we will not be covering those tonight. Those are specialized areas, and if you have questions about them, I would definitely encourage you to meet with a lawyer and discuss that. Tonight, we're talking about what's called revocable living trusts, sometimes known as living trusts, sometimes simply called trust agreements, but that's what we're dealing with tonight as we go through this seminar. So I thought it would be good first to put everything in perspective. As I mentioned, I've done a number of these seminars, and they have covered the general topic of estate planning. And so I thought with this first slide, we should talk about what are some of the estate planning documents that go into making an estate plan. So you can see I have durable power of attorney. There's the patient advocate designation, also known as a medical power of attorney. There are wills and there are trusts. So our powers of attorney, one is for finances and the other would be for medical decisions in healthcare. Those are what I call pre-death documents. Those are documents dealing with incapacity, where you are no longer able to do those functions for yourself. And so you name someone in a document who can step into your shoes and do those functions for you. And that would be one concerning finances, that's your general durable power of attorney, and two for medical decisions, which would be, again, your medical power of attorney. So those are pre-death. But what if you want to make sure that your wishes are carried out after you die, and you want to make sure that there's a plan in place for distributing your assets at death? So that's when we turn to wills or trusts. And there's always the question is, do I need a will or do I need a trust? And so hopefully part of this presentation will be answering that question. But again, we're focusing on trust. So to know whether one is better than the other for you personally, we should talk about wills so you understand what they do, and then we'll talk about trust so you can understand what they do. So wills have statutory requirements. In order to be valid, there's a statute that talks about what a will needs. So it needs to be signed by the testator, is what we call, and that's the person who essentially is creating the will. And the wills need to be dated. The wills need to be witnessed, so that would be two witnesses. Notarization is not a requirement, but it's strongly advised to have a will notarized for the validity and effectiveness of the will. So these are some standard requirements for a will. Wills equal probate court. So this is where people get tripped up, because the general understanding is that if you have a will, then you avoid having to go through a probate court process. But that's not true, because the probate court is the entity that oversees wills. So I just had mentioned in the previous slide that there are some requirements for a will to be valid. So who is the entity that oversees that to really make sure that the will is valid? And that entity is the probate court. So there are exceptions to this, but the general rule is that wills equal probate court. So if you are going to a lawyer and you are going to get an estate plan put together, understand that if you decide you want a will, which in some cases is perfectly fine and may be appropriate for you, that there is a great possibility that it will involve the probate court. So then what does that mean? Because we hear the term probate, and sometimes that's considered a negative term. So let me just give you a sense of what that entails when I say that probate court would be involved. Well, it means that there's a process. And the process is that you have to file the original will with the probate court. So this is the original document that was actually signed, not a photocopy. If you only have a photocopy, there are ways to still go through the process, but those ways are going to be time consuming. They're going to be more expensive. They're going to involve court hearings. So ideally, you want to make sure you have the original signed will. There's an application that's involved, that you file an application with the court. There's an application fee. Then the court appoints what's called a personal representative. This is the person that you name in your will, and this is the person that you are naming who you want to administer or manage your affairs for you. What happens is the court makes it official. So when you create a will, you are stating your preference for who should oversee it, but it's the probate court that actually essentially blesses that process, who says, okay, this is the person you name, and so this is the person who will be in this position. So that person receives what's called letters of authority. It's a document. It's typically a one-page document that says that this individual has the authority to administer this estate, to manage the affairs. Along with that, there are other requirements, and these would be what we call notice requirements. One of the big notice requirements would be publishing a notice for creditors. So some of you may have heard that. There's an inventory that needs to be prepared. There are fees that are associated with the inventory. There's what we call accountings, and these accountings are showing anything that came in to the estate, so income to the estate, but also expenses that were paid from the estate. And there are other annual reports that are involved. So just in general, these are some multiple steps that are involved in the probate process. And when we refer to the term probate, this is a process that we're talking about. So what are the concerns? So what is it that drives people away from wills and to trust? Well, one of the concerns is that they say that wills are too expensive, that the probate process is too expensive. I mentioned in the previous slide some fees that need to be paid as a result of the probate process. People don't like the fact that you have to pay fees. So that's one of the complaints. Another complaint is that the process takes too long. And that can be true, but the bottom line with probate is that the process itself, there's not a mandatory setting where it has to take a long time. Actually, the probate process can be completed in 5 months if all the assets are gathered in and liquidated in that 5-month time. And if creditors are paid and expenses are paid in that 5-month period and notices were given, then you can close an estate as soon as 5 months into the process. But if you have an asset in the estate that hasn't been sold, and you have distributions that haven't been made, or you have creditors that haven't been paid, then that will delay being able to close the estate. So in terms of it being too long or time consuming, it often depends on the kinds of assets that you actually have in the estate, and not necessarily because of the court process. Another concern is the court is involved. Yes, the court is involved. As you saw in my previous slides, I said that wills equal probate. It is a court process, and so that is the involvement. Litigation, there's concerns that if you open the door to the court, that it's actually going to induce more in terms of litigation and complaints between the parties. And that sometimes happens, but that's not always the case. And typically, if there's problems and conflicts within a family dynamic, that's going to create problems regardless of what document is used. And then another concern is it's not private. And this is true. You have a probate estate is a public record. And so it is open to the public. And so you are losing some privacy. However, there are some court forms that have been developed over the last few years. And those forms are specifically for personal information like birth dates, social security numbers, driver's license numbers, etc. And those forms are kept separate from the public format. So there is a way to at least protect some private information. So that's wills. Those are the concerns. So as a result of that, people sometimes turn to trusts, because what trusts do is they provide an alternative process for distributing your assets, and trusts do not equal probate. So for some people who really, really want to avoid probate, they turn to a trust. So this is the anatomy. We're going to go through the anatomy of a trust because it's not an easy document to really understand. But first, we're going to start with the parts of the trust. So as you can see in this overview slide, we have a trust is a document. So it is a legal document. It's typically an agreement. So sometimes it will be referred to as a trust agreement. And the idea is that this is a document that's binding the parties that are involved in the process. So these are the parties. So first of all, who creates the trust? That person is known as a settlor, grantor, or trustor. So if we were to put a face to that person, let's assume that would be a parent. So a parent creates the trust. Then you have an administration, because you need to know who is going to carry out these wishes, who is going to administer this trust. And so the person who administers the trust initially, the settlor, so the person who creates it, is typically the person who administers it initially. And that title is trustee. So you have a trustee who is the individual that administers the trust. And so in our example, the settlor is the parent, and initially the trustee is also the parent. Now, if that parent is no longer able to be trustee, then we have what's called the successor trustee. So this is the backup person. And why are we creating the trust? We're creating the trust so that benefits can now be given to individuals that we name. Initially, the settlor is the primary beneficiary of the trust. So initially, you have a trust that was created by someone, settlor. It's administered by someone, the settlor. And the settlor is the person who benefits from the trust. So initially, that's what it looks like. But if something happens to the settlor, if the settlor no longer has capacity, they're no longer able to administer their own trust, then you have a successor trustee who steps up. But the settlor is still living. So the settlor is still the one receiving the benefit from the trust. As long as that settlor is living, that person or parent in the example is still benefiting from their trust. However, when that settlor dies, then we look to the trust to see who would be receiving those assets, and that would be any other beneficiary. And at that point, we have a successor trustee who has stepped up, and now the job of the successor trustee is to provide for those other beneficiaries. Okay. So that's an overview. Now we're going to break it down into parts. Before we get there, one of the things you need to understand is that creating a trust is like having a baby. you are creating in what seems to be an entity, but in some ways it wants to be a living, breathing entity, in that there are steps that you need to follow in the creation of a trust. It's not the same as a will that's created, and once it's done, it's done. You put it on, in a file drawer or in a safe deposit box, and you're good to go. A trust, there's some work that's involved in this process. And so that's why I liken it to having a baby, because once you have the trust created, I'm like the pediatrician that delivers the baby to you, but you take it home and now you have to nurture this trust. And so you have to be willing to do that if a trust is a good instrument for you in the first place. If you're not willing to put time into a trust, and you're really not willing to think about it in terms of nurturing a child or a baby, then maybe a trust is not the way to go. So keep that in mind. So here's the anatomy. We're breaking it down. As I said, first we start with who created the trust. And I mentioned that the terms given to the person who creates the trust: settlor, grantor, trustor. And as I mentioned, this is often a parent. The most common term that we see out of these three is the term settlor. That's what you're most likely to see. And as I had mentioned before, what happens is that an individual goes to a law office and they say, I want to put together an estate plan. Whoops, I went too far. Let's go back. I want to put together an estate plan, and I'm thinking about a trust. So I want to know if this is the right plan for me. And so the lawyer will ask questions like, well, how do you feel about probate? If you hear the term probate, does that cause some emotion in you? Have you had or heard of bad experiences with probate? And it just generally get a sense of what this person thinks about the probate process. There are other questions that are involved. We have to consider the family dynamics. Are there minor children? Is this a blended family? Are there any children with disabilities? Do we have any children who have some issues, maybe substance abuse issues or issues handling money? All of these things come into play in deciding whether a trust is the way to go in certain situations. Moving on, the trust is empty when you create it. So we're going to spend some time talking about, what do you do with this trust? One of the biggest issues that I run into as a lawyer administering trusts is that I have clients who went through this hard process of creating a trust with a lawyer, but they never really put things into the trust. And so what they have is this empty trust. I mentioned that the trust is like a baby. So think of it in terms of nurturing a baby. What do you have to do? You have to feed the baby. So we're going to look at feeding, or better known as funding, the trust. So how do you do that? What do people do? So we have the settlor. I mentioned that term already. I said typically that would be a parent. And the settlor owns assets. What kinds of assets? Well, a house, possibly, a life insurance, bank accounts, investment or retirement accounts. Those are all things that someone might own. And so we have to decide, looking at those items, which of these items should become trust assets. And essentially, there are some items that are what I call healthy items for the trust, and there are some items that maybe aren't so healthy. So again, using my analogy of having a trust be like a baby, when you take your baby home from the hospital, you're not going to start giving your baby candy and alcohol, right? Those are not healthy things for your baby. You're going to give your baby the right types of food at the right time. So in some ways, some of these assets are like candy and alcohol to a baby. So if we look at each of them, a house is what I call a relatively safe asset. There's really no huge disadvantage to transferring a house into the trust. So what we're doing is, as I said, we're feeding the trust, we're putting these assets into the trust. So that would be an example. That is done by a deed. Life insurance. You can name the trust as a beneficiary of life insurance. So in many cases, let's say you have a married couple, husband and wife, and they may choose to name each other first as the primary beneficiary. But if they have a trust, they may want to name their trust as a secondary beneficiary. That would be an asset that's perfectly fine to put into a trust. Bank accounts. Again, with a bank account, you can name your trust as the beneficiary of an existing bank account, or perhaps you want to create a new bank account in the name of the trust. And so think of it as if you were setting up bank accounts for your children. In this case, you're setting up a bank account for your trust. Okay. Investment accounts, retirement accounts, those types of accounts, that's like the candy and alcohol. We have to be really careful about these kinds of accounts and what we do. And the reason why is because these types of accounts have a lot of tax consequences linked to them. And as a result, I always advise my clients, if you're thinking about this type of transfer, then first you need to meet with your financial advisor and you need to assess what these accounts are like and what kind of tax implications may come as a result of transferring them to your trust. Most of the time, we're going to advise that you would not rename them to your trust, that would be a bad move. But we might want to name your trust as the beneficiary. Again, if you're married, you'd still want to name your spouse as the primary beneficiary and then perhaps your trust as the secondary beneficiary. Now moving on to the anatomy, we talked about who administers the trust. And I mentioned that initially, the settlor is the initial trustee. So what that means is if you create a trust, then you are going to initially be the trustee of your own trust. Unless there's some reason specifically why you shouldn't be, that would be the case. So as long as you have capacity, again, if we look at our example of a parent creating a trust, as long as that parent has capacity, that parent would be the trustee of their trust. Okay. What happens if the parent does not have capacity? Well, I mentioned that there's another role called the successor trustee, and you can consider the successor trustee to be the backup trustee. So there are two events that trigger when a successor trustee steps up. The first event is when the settlor no longer has capacity. So this is a situation where the settlor is still alive, not dead, but they no longer have the ability to manage the trust, in which case your successor trustee would step up. Okay. The other event that triggers the successor trustee is when that settlor dies. And then at that point, the successor trustee would step up and would manage the trust at that point. Who determines in the first event, who determines if that settlor no longer has capacity? This is spelled out in the trust. The trust itself should address that question. And so you can have a number of options. I have seen trusts that say if two physicians, after evaluating the settlor, decide that the settlor does not have capacity, then that would be the trigger event. So that requires two physicians. I have seen trusts that say that it is determined by a court. So if a court determines that the settlor doesn't have capacity, then that would be a trigger event. Now, that seems contrary to me, because if one of the reasons for getting a trust was to avoid court involvement, why build that into the trust to say that a court is the one that determines capacity or incapacity? That doesn't seem like it makes sense to me. So I would avoid that. Another way of making that determination, oops, I'm moving again, is that there's sometimes language that says the successor trustee can make that determination. So let's go to our parent example again. Let's say that the trust was created by mom and that the successor trustee is son. What this is saying is that at some point, son could make the determination that mom is no longer able to be the trustee. And if son makes that determination, then son can now step up as successor trustee. I would say that's probably the most common trigger event, but as you can see, you have to be very careful about it. If son has a complex of some sort, or if son is trigger happy, or if son is in a position where he's not necessarily trustworthy, one, he shouldn't be named as a successor trustee, but two, he's the last person you want who has the power to oust the first trustee. So you have to be careful with that. And then continuing with our anatomy, received by, who benefits from this trust? Well, initially, as I said, we have the settlor is the one who benefits from the trust. So if your parent created the trust, and while your parent is living, your parent is the trustee of the trust, well, then that parent is also the primary beneficiary of the trust. But what if the parent is now incapacitated? And now you have your successor trustee that has been triggered, an event has been triggered, so the successor trustee steps in. The parent is still the one who benefits from the trust. While that parent is living, then the successor trustee, the role of the successor trustee is to make sure those assets are still available for the parent or any of the dependents of the parent. Now, when the parent dies, now we have a new set of beneficiaries. Now we have the individuals that were named in the trust to receive the trust assets when the parent dies. So that could be a variety of beneficiaries. Most likely it's going to be the children or descendants, or maybe other people may have specific gifts mentioned in the trust. So you may have a family member who gets a specific dollar amount gift, or there may be a charity that gets a specific dollar amount gift. But all of these individuals are now in a position that they're going to be benefiting from the trust because the settlor/parent has died. So trusts, what are the pros? Well, we talked about it does not involve the court, and that's the general rule, is it does not involve the court. However, if there's conflict concerning the trust, it is the probate court that resolves that conflict. So if the trust is contested, and let's talk about what would that mean? Well, let's say that there's a problem concerning the successor trustee. Let's say that in my example where we had a parent and the son has determined that mom does no longer has capacity to be the trustee of her trust. Well, let's say sister doesn't agree with him, and sister thinks that he's just power hungry and he's just trying to push mom out of the way so he can take control of it. Well, that might result in a contest concerning the trust, and that could result in litigation that would be handled by the probate court. A trust does allow for creativity and some flexibility. I mentioned in terms of what are some of the situations where a trust is a good tool. The creativity of a trust really allows for those situations. And so what are we looking at? Here are some situations. I mentioned special needs planning and public benefits. I mentioned blended families. I mentioned problem children or children who are just having issues. I mentioned minor children. The language in a trust can be used to protect and preserve those kinds of situations. By having a trust, you can have children receive gifts at a later date. They don't have to receive everything at the age of 18. Maybe you want to postpone that and you don't want them to receive everything until they're age 30 or 35. You can do that with a trust. You can say in your trust what you want. With special needs planning and public benefits, anything dealing with long-term care planning, trust can be very special tools used in helping in those situations. So trust is, there's a pro for using a trust when you have those kinds of situations arising. I mentioned blended families. That comes into play. For example, you may have a husband, he has children from a previous marriage, wife has children from a previous marriage, and they each want to make sure that those children are protected in some way, and they don't want the new spouse or step parent to turn upside down their estate plan. And a trust can help with that. It can really help preserve those plans. If you have a child who has issues, a substance abuse issue, bankruptcy issue, and you're concerned that if that child, if she received a distribution after you died, that might just go up in smoke. Well, you can build in some language in a trust to help preserve that distribution for her so that it's held in the trust for at least a period of time so that she's not essentially in a position where she could lose that distribution. The trust is useful both in death, as we've been talking about, but also, as I mentioned, even in incapacity, it's very helpful too. When there's incapacity, as I mentioned, the difference is that you would have a successor trustee step into the shoes of the then acting trustee. However, the settlor is still the primary beneficiary in that case. So all that happens concerning the trust is still for the benefit of that settlor, but for the fact that the settlor is incapacitated and needing that extra help. So what are some of the cons? Well, trusts are complicated. I mentioned that having a trust is like having a baby. You get to take that baby home, but you have to nurture the baby. There are some things that come along with it. Trust language is very hard to understand. There's a huge portion of trusts that deal with tax laws, and most of us are not as familiar with them as a CPA or accountant would be, and so it's difficult to understand. So they can be complicated. But there are certain provisions that are very important for you to understand, and those are the provisions dealing with distributions. What do you want to happen to your assets? And so it's important to still have a grasp and an awareness of what your trust can do. Trust can be expensive. In comparison to wills, trusts are going to cost quite a bit more. And that will vary from one law firm to the next. But the general rule and the general idea is that you're going to pay more for a trust than you would a will. So when I talked about wills, and some of the concerns were the fees that had to be paid to the court, well, you almost have to evaluate whether those fees are going to outweigh the expense of a trust, because maybe in the long run, a will ends up being a more economical document, even though there are fees that are paid. There are multiple steps required with the trust. As I mentioned, feeding or funding the trust is a primary piece to having a trust document in place. So you really need to make sure that you go through the steps of transferring assets into the trust. But as I said, it's not just so simple that you transfer everything. You don't want to give the trust candy and alcohol. Okay. A trust sometimes requires its own tax ID number. Now, a tax ID number is not that complicated to get it. The IRS has a website, irs.gov, and you can go to the website to apply for a tax ID number, but just be aware that sometimes having a trust will require that step. Litigation, I mentioned, you don't necessarily avoid litigation by having a trust. If there are issues in the family, there are going to be issues regardless, and it may result in litigation, which in turn results in you in the trust document ending up in probate court. And then with the trust, there are the successor trustees. As I mentioned, you really have to be choosy about who you name as your successor trustee. You don't want someone who's going to be power hungry and who wants to take over too soon. So let's talk more about the trustee or the successor trustee. So if you are the trustee, so if the settlor is acting as the trustee, well, then there's really no special duties that the settlor owes to himself or herself. So for that process, when the settlor is the trustee, things are relatively smooth and under the control of the settlor. However, if there's a successor trustee that steps up, that successor trustee has some statutory duties. And I say statutory because these are laid out. This is part of the law concerning trusts and trustees. So there are steps involved in the process as well. The successor trustee needs to sign an acceptance to say she's willing to be the successor trustee. Successor trustee needs to send notices to all of the beneficiaries, letting them know, I'm the successor trustee now, you are a beneficiary, and this is what you get. The successor trustee has to provide a copy of the trust and any additions to the trust called amendments to these beneficiaries. The successor trustee needs to put together an inventory of the trust assets so that the beneficiary understands what's in the trust, what assets are there, essentially how much money is in this trust. Accountings, this is keeping the beneficiaries informed. What income has come into the trust? What are the expenses of the trust? So that would include legal fees. That would include any compensation to the trustee. A trustee is allowed to be compensated a reasonable fee. So that is something that the beneficiaries need to be aware of. And then, of course, the successor trustee has the duty and obligation of liquidating the assets. So if there are assets that need to be sold, for example, a house, the successor trustee needs to work with professionals to get that house sold. If there are retirement accounts, investments that need to be liquidated or dispersed, the successor trustee needs to work closely with the financial advisors to make sure that that happens. There's a lot of paperwork involved with the successor trustee having to fill out claims forms to be able to access those assets. Successor trustee may need to open a bank account. If that was never done for the trust initially, then the successor trustee may need to do that. And then, of course, the final piece is that the successor trustee needs to make distributions. And that can be very tricky. Again, if you have family dynamics where people are opposed to each other, that could be the start of litigation once we're talking about distributions and who gets what. So there are many steps involved in duties of the successor trustee. So we need to talk about assets. I talked about funding the trust, and in general, we always want to make sure whether we have a will or a trust, we want to make sure that assets have what I call a home. And that means that we want to make sure that assets have somewhere to go. And whether you choose to do that in a trust or whether you have a will, whether you use joint ownership, whether you use beneficiary designations, you want to make sure that those assets are somehow tied or linked to something. If the assets are not linked to something, then you have what I call homeless assets. And those are assets that are not in a trust. There's no beneficiary designation. There's no joint owner on the asset. It's essentially hanging out there and it does not have anywhere to go. When that happens, then essentially now we're back to where we started and the will comes into play and will equals probate court. So wills really still are part of the picture. Even if you have a trust, you still have what's called a pour over will. And that is a special type of will that catches what we would call the homeless assets. So if you have a trust and you went through the process of nurturing that trust, feeding the trust, and you've done a very good analysis of all of your assets, and you've made sure that your assets are linked somehow to that trust, then this should not be a problem for you. But if you missed some assets and some assets ended up not being linked to your trust, meaning that you didn't retitle them into the name of the trust, or you didn't name your trust as the beneficiary of the asset, or there are assets out there that don't have a joint owner or something tied to that asset, then at that point we need to use this special will to access those assets. So if your goal was to avoid probate court, then you've essentially not failed at that, because now we have probate court involved in this process. So this is a pour over will. You will not see the title pour over will. Typically, it's only a few cases where I've seen that, but it is a special will that's used when there is a trust, and the will refers to the trust. So the idea is that if indeed there are assets that end up in this process, then those assets ultimately are made back or make it back into the trust, but it has to go through the probate process to do it. So now what you're looking at are two processes, both the trust process itself, but also the probate process. And you have situations where now you, as I said, you failed at your goal. Something else you should be aware of is that out-of-state assets require probate in another state. So if you have a trust and you happen to have, for example, Florida property, which some of my clients have that, it's important that you can't forget about that Florida property. You want to link that Florida property to your trust by having a licensed attorney, a Florida licensed attorney, prepare a deed that transfers that into your trust. Because if that doesn't happen and you die, now you have this out-of-state property that requires probate out of state. So I know that was a bit complicated and tedious, but it's something to be aware of, that when you have a trust, there's always a will, and that will is essentially a safeguard to the trust if there's anything that goes faulty with the trust. So as I summarize, trusts need to be nurtured. They need to be funded. They're great tools, and they are good for many people under many situations. But it's important to realize that when you have a trust, the assets, you need to look at your assets, and you have to make sure that those assets are linked to your trust somehow, as a way of making sure that the trust is funded and that your goal of avoiding probate actually happens as a result of your trust being properly administered. So Therese, we still have some time on the clock. And I don't know if there's any questions that came in through the Q&A during the presentation, but certainly we're open to questions at this point.
Sounds good. Yeah, we'll go ahead and just get to those in a moment after we conclude recording. So I just want to thank you again, Michelle, for being here this evening. I think you touched on a lot of great points and just having that firsthand experience and, getting those questions from your own clients. I think that's really helpful in the situation for maybe some things that we haven't thought about up until this point. So for those of you not staying for the discussion, I invite you to take the survey that will automatically open after the event to allow us to consider your feedback. Additionally, don't forget to join us for some of our upcoming sessions. Our next webinar, Home Buying Basics, will be Tuesday, March 19th at 6 p.m. And if you're in the greater Lansing area, we have an in-person session with our financial solutions team through MSU FCU about retirement income planning. And that's going to be on Tuesday, March 26th at 6 p.m. at our Farm Lane Branch Community Room. So with that, I'll go ahead and stop recording and then we can address the questions that were submitted to the Q&A.